what about confidentiality for those clients?
Can everyone hear me? I have a reasonably loud voice, so it's usually not a problem. We do quite a lot of training on confidentiality. Are there any aspects in particular?
What I was concerned about was in regional areas, particularly smaller
I'm with you.
towns, there's a relationship between clients and staff.
It hasn't been, so the issue is really, wonderful. The issue is really in a small community. I'm just going to yell. In a small community, how do you maintain confidentiality, and particularly for our staff? How do they make sure they're not mediating a case where they know either or both of the parties? In our training, we do a lot of work around that. In some communities, it's unavoidable. However, because our staff, although they're regional in reasonably sized centres, by and large, in the main sort of provincial town or city in the region, it hasn't been too much of a problem. What will generally happen is if it becomes an issue during the course of the intake that one of our staff members or the mediator that has been assigned to that case knows either, we rely on them to tell us that they know a party so that we can put somebody else in. But that's effectively how we deal with it.
Thanks. It's Chris Humphreys from the Victorian Department of Justice, and Neil, I won't ask you a Dorothy Dixer. It's probably a question to both of you. Over the last 30 or so years, the rhetoric around community and the law has focused on empowerment and demystifying the law and getting the clients to take control of their dispute or of their problem and giving them the information to be able to do that. And I was just wondering if you could comment on how far you think that can go, given that law is quite a technical area, perhaps increasingly technical, and how successful those efforts have been at co-production over the last 30 or so years.
Yeah, good question. I actually think that it's about sort of shifting the culture of the law, and in some ways I think that we can go a whole lot further. For most people, the law just, well, for most legal aid clients, they walk out of the court system in that formal sense and have no idea what went on. So in terms of empowerment, that clearly doesn't hit the spot. I am a great believer in this earlier dispute resolution approach, and I've seen firsthand in a lot of the family group conferencing matters that I've also attended, where the young person, in that case, absolutely actively involved in the the restorative justice process, and they understand a whole lot more, and it's a whole lot more confronting than that formal court sense. So I actually think that the empowerment issue is going to be more outside the formal court process, but I'm a strong believer that the culture itself of the legal system has to change quite significantly still.
From my point of view, for us, I suppose the main driver is that although people may not have a great deal of awareness about what their legal issue is, they certainly do know when they're in a dispute with someone. And that's very much where we devote our efforts. Although once it does get into the legal arena, and we've got one of our projects with the Magistrates Court around the diversion of civil disputes which have been issued in court, so they're fairly and squarely within the legal arena. But even those, by and large, because of the nature of the disputes, they're not really about a legal problem. And we've worked very closely with the courts to push that mediation with the legal profession. And I must say, our main sort of opposers, I suppose, to that idea are the local law societies, and they always find it a bit of a challenge that we're trying to take work away from them. And what we keep saying to the lawyers and what they come to realise after they've been working with us for a while is that there's still very much a place for lawyers in advising people of their rights and making sure that their rights are held up. But I think what ADR does is it creates an environment for a very different type of legal practice, and a type of legal practice that is much more about ensuring that the client has their say where they want to. And what we find in a lot of those mediations where it is more in the court context, and what we've found in another project that we're running in the higher courts, where we actually have the judges hopping down off the bench and conducting dispute resolution, is that when the judges encourage the individuals to actually speak up, they get to a resolution often reasonably quickly, rather than when they've got the lawyer intervening. I'm not sure if that answers the question, but it's kind of an interesting phenomenon.
Can I just add also that that whole role of, or rise of the community legal education is absolutely huge. And, you know, courses around law for community workers are the most popular courses we now run. And the other really important initiative, and it's perhaps a New South Wales-centric one, but there are similar things in other states and territories, I'm sure, is this sort of telephone law access approach. So something like 45,000 calls from Law Access, which is a big 50 call centre setup, were referred into legal aid. So the first stop shop now is Law Access, and all our posters and banners and a front of house sort of phone access thing is Law Access. So people get really good information, a lot of it sent out to them, and then if they need to, they'll then come into legal aid. So, you know, there's lots of good initiatives like that going on.
Thank you. Over here, please.
My question's probably more for Richard.
You are?
Oh, sorry. My name's Ali. I'm from Prime Minister in Cabinet at the federal level, but formerly of your counterpart, Richard, in Queensland. Probably a similar theme touched on in the last session in the Indigenous workshop, policy delivery workshop, was about the Commonwealth agency and state agency needing to present a common front to the client. The client isn't interested in whether their service is funded out of a bucket of money that the Commonwealth has or the state has. Your services, Richard, are divided, from what I understand, quite like that. The criminal services and family services come from different buckets of money. If a client is presenting with multiple problems that cross those buckets, what intake processes and co-production internally do you have to present that single front to the client?
Look, just to, let's not forget that the bulk of Aboriginal clients, and I know your question's not specifically about Aboriginal clients, but the bulk of Aboriginal clients in criminal matters are represented by the Aboriginal Legal Service, and we're an absolute champion of that, the importance of the Aboriginal Legal Service in criminal matters. In family and civil matters, due to the lack of funding for the Aboriginal Legal Service, we tend to look after most of those matters in New South Wales. But in terms of that holistic practice, what we're finding really successful is that a lot of our lawyers are having, you know, a bit more fluidity around the organisation, so that it means that they can have skills in family, civil and crime, for example. What would be ideal, and it was sort of something promised a few years back, would be that whole parity of salary around for community legal centres, for the Aboriginal Legal Service and for Legal Aid Commission staff. Because if we had that parity of salary, it means that there could be a whole stack of movement across those different areas, and it means that I think that the client would seriously be in a position to get a one-stop seamless sort of approach. And it was something also that I picked up from Lynelle Briggs, where she talked about what people really want is a personalised service, as you're saying, and a one-stop shop. I mean, it's just fundamental.
Very good, thank you.
And we also make sure that with the private practitioner and the in-house lawyer that we try and guarantee continuity as much as possible. So we get the one solicitor, ideally, to look after the person in virtually all their matters. So that's what's also critical, the one solicitor. That, you know, clients don't want 3 or 4 solicitors.
Don't be bashful. Please, down front.
Thank you. My name's Susan McHattie. I'm with Finance and Services in New South Wales. Neil, I'm interested in a story that was kind of embedded in your presentation about your staff starting off, I think, in a call centre situation and then moving into a more proactive kind of mediating role. Could you tell us a little bit about that development and what started it and what challenges you faced on the way?
That transformation was a great thing, and so the staff had largely been in a call centre environment because of the location of the dispute settlement centre, because it was in Melbourne, and the mediations are conducted locally. The calls used to come in, the staff would do the intake and the risk assessments, and then basically book the venue and get the mediator, and the mediator would go out and do the mediations. When we started regionalising, it seemed to me that that was a great lost opportunity, because we actually train all of our staff to be mediators, and it seemed to me that we were investing in staff to be mediators but not really using them for that. They were being call centre operators, which is fine, but it was a bit of a waste of their mediation skills. It also had a bit of an effect on their morale, and it came through in our employee surveys that, you know, they were saying, well, you know, I came here because I wanted to do good work in mediation and I'm sitting on the phone all day. So the opportunity with regionalisation meant that we could have a think about how we managed the work of staff. But the big change came when previously essentially the business model, if you like, was that if you were on that call centre on the phones, you had no ability to make a decision about whether a case should settle or not. You had to follow it through and send it off to mediation. When we decided that those staff would have the ability to make the decision, that's when you see that big jump in the dispute assessment officer settlements, because a lot of what they will do is, in the preparation of the case for mediation, shuttling between the two parties, is they'll be able to get the parties either to settle it themselves or they will either do it over the dispute assessment officer will do it over the phone. But also, because we started to work, when we regionalised, we started to work much more closely with local courts and being at court in order to take those referrals from the court around intervention order applications. So what tends to happen now is that the staff, when they take those referrals, if both of the parties are at court, and if they both want to have a mediation, they'll do it on the spot. And the staff responded to it incredibly well, because it was what they always wanted to do. So as a change management program, it was fantastic, because, you know, normally you go to places like ANZSOG and learn that, you know, change management programs are very difficult because people don't, you know, and they normally are. But this was fantastic because our staff were actually wanting to do this stuff that we had not previously given them the opportunity to do. So it was actually very easy. A bit of a risk, because it relies on the dispute assessment officer's experience to tell them whether or not they should take on a mediation or not. But you really do